morning, and I thank you for coming, and I look forward to a very interesting talk by Professor Sharp. I will introduce very briefly Professor Sharp. He's a professor in the Emeritus College at Arizona State University. He's a former research associate at Stanford University, and he also a former director in the U.S. Department of Education in Washington, D.C. He has taught at the universities of Maryland, Maine, Virginia, Virginia Tech, Utah State, Weber State, and Arizona State. I need my glasses. He did postdoctoral studies at the University of Sussex and was a visiting scholar at Oxford University in 98-99. He lived and worked in the Middle East. He has authored 18 books and has over 240 articles in the social and the behavioral sciences, humanities, and teacher education. He has been a foreign correspondent for the Salt Lake Tribune and a contributor to several newspapers. He has been published in the US, England, Finland, Norway, Germany in German, India, Malaysia, China in Chinese, Hong Kong, and Denmark in Danish. He has been awarded 3 Fulbright scholarships, one in Malaysia, Cyprus, and Denmark, and sponsored by the governments of Malaysia, China, South Africa, Mongolia, Kazakhstan, Uzbekistan, and universities throughout the world. He was a distinguished visiting professor at the Qinghai Normal University from 88 to 94, and was the first American inducted as a fellow in China, in the China Senior Professors Association. In 2008, he was awarded a Lifetime Achievement Award by the International Studies Group of the American Educational Research Association. This is where I met Donald Sharp. We have worked together. I'm a member of the same association. We have worked together as members in the International Studies Group, and we have worked together also as in publishing. Some of the books he wrote, The Evolution of the Social Sciences, is his latest book. Outcasts and Heretics, Profiles in Independent Thought and Courage, that's in 2007. Sacred Bull, Holy Cow, a study of civilization's most important animals, that's in 2006. He has many books in education, on foundations, history of education, in educational psychology, in educational research, and many other topics. I am very pleased and honored to introduce Professor Donald Sharp. Welcome to Lebanon.
Thank you, Dr. El Hassan, for that very kind introduction, and I want to thank the Center for American Studies and Research also for their kind sponsorship to come to this ancient land of the Canaanites and the Phoenicians to welcome you. So I'm going to talk to you a little bit about the history of constitutional principles, and the subtopic is civil law and religious imperatives. And I'd like to begin by quoting a part of the First Amendment to the U.S. Constitution. And I'm going to repeat it again and then explain why I think it's relevant to this discussion. Congress shall pass no law respecting the establishment of a religion, nor prohibiting the free exercise thereof. It's a relatively simple sentence, but it contains, in my view, the core of civil law and how it affects not only Americans, but everyone in sense in the world. I'm going to repeat it again to you. Congress shall make no law respecting an establishment of religion, nor prohibiting the free exercise thereof. Now, there's two parts of it. First of all, Congress shall make no law.
What year is this? What year was this?
1787. Thank you. So, Congress shall make no law respecting an establishment of religion. Because in Europe at the time, there were established religions, and in fact, they are still there. But more importantly, in the colonies at the time, before the Constitution was written, each state had established religions. The Anglicans in Virginia, the Catholics in Maryland, there were French Catholics in the Northeast states, Vermont and New Hampshire, Maine at the time. So religion was a very important part of civil government during the American colonies. The second part of this famous clause is that Congress shall make no law respecting the establishment of religion, nor prohibiting people from practicing their own religious faith. So first of all, it's a prohibition against government. Up until this time, we had thou shalt not, prohibitions against individuals. Now we have prohibitions against government itself. This is a revolutionary idea in civil law, it seems to me, and one that's so very important. And what I want to explain to you is a brief exploration and analysis of how this came about, the history of these constitutional principles. But may I first go back and talk about the Greeks, specifically the year 458 before the Common Era in Athens, when Aeschylus's play, the Orestria, was first produced. It's a very, very important play. And if I can, I know the names of the protagonists and the antagonists are complicated, but I want to go through it with you and then show you why this play is relevant. First of all, there's Agamemnon. The whole trilogy is about the house of Atreus, the house of Agamemnon, king of Mycenae, who must go to fight King Priam and Troy, as exemplified in Homer's Iliad. But he is encountering, as I'm sure most Phoenician sailors did hundreds of years ago, unfavorable winds. So he pleads to the gods to help him get favorable winds so he can take his almost mutinous sailors and soldiers over to fight King Priam. Well, the queen, Athena, the goddess of wisdom, says that first you must sacrifice your daughter Iphigenia. Now, Agamemnon's wife is named Clytemnestra. They had 3 children, Iphigenia, Orestes, and Electra. He must sacrifice one of his daughters in order to get the goddess's permission to sail across to fight at Troy. He does that with reluctance, one can imagine, and he goes to fight in the wars of Troy. They are successful, as you know. He kills King Priam, and the whole war, of course, was to rescue Helen, whom Paris had abducted. Paris, after whom the City of Lights is named. He comes back to visit his wife and family in Mycenae. Meantime, his wife, Clytemnestra, has taken up with Aegisthus, and he has brought back from Troy his mistress Cassandra, the sister of Paris and the daughter of King Priam. But in the meantime, Clytemnestra, in an act of revenge, in consultation with her new husband, kills Agamemnon and Cassandra. Orestes, the son now, returns from banishment and decides to kill his mother in consultation with his sister Electra. Well, and you thought you had a dysfunctional family. This is a tragedy in the making, of course, but the whole idea is now, what do you do with Orestes? Well, Orestes must be put on trial, and Apollo agrees that he must be judged. Athena, the goddess of wisdom, however, says that he must be judged by men, not by gods. And he is to be put on trial by a jury of his peers. This is unique, and Aeschylus is very clear to say this is the first jury trial in history. Now, whether it was or not, we don't know. But the point is, it is justice now not administered by the deities, but by men who will judge the guilt or the innocence of this particular man, Orestes. He is put on trial. We would say it's a hung jury because it was split. And Athena grants the deciding vote to acquit Orestes of this murder. Now, for me, this play represents a unique moment in intellectual history. First of all, it is the end of blood feuds, personal vendettas, clan rivalries, and it is the institution of a form of civil law where humans will decide the fate of other humans, not just gods. So we can fast forward a little bit now and actually go backward in time and discuss some of the other important events, it seems to me, in civil law that affect the points I want to make here about how religion and civil law are always in conflict with each other. And I want to take you back even further in time now to about the middle of the 18th century before the Common Era and the Code of Hammurabi. Now, there was an earlier code that we know about. It's called the Lipit Ishtar Code, but it only has about 9 injunctions that were inscribed in cuneiform tablets, and we don't know much about them, but most of them contain prohibitions against thieving somebody else's crops, had to do with agriculture and gardening and so forth. So now we have a code by the founder of Babylon, not just anybody, but King Hammurabi, who founded Babylon, a very, very ancient civilization. And you can see it today in the Louvre. It's an 8-foot-tall basalt, solid rock, and it is inscribed with 282 laws that contain prohibitions and injunctions against all kinds of activities, against merchants, barbers, sailors, husbands, how to deal with their wives, how to deal with the children, how to work with slaves, what to do about agricultural products and trade shipping. It is a comprehensive legal code, the oldest one that we know of in the world that is so thorough. So Hammurabi started this code, and it became the basis, but it was only discovered, archaeologically speaking, in 1902. So it's fairly recent. Prior to that, no one knew that there were such earlier codes of justice. Another 500 years elapse, and we come to Moses, that Hebrew man with an Egyptian name. And he goes up to Mount Sinai and gets 10 commandments. Well, voila, they are very similar to Hammurabi's codes. You can find parallels between them, about 6 or 7 of them. The most important ones contain no other gods but Yahweh. No other gods against Yahweh. So there's a prohibition about graven images. You will find this comes up in other religious practices as well, won't you? Well, it's very good not to have graven images, but it relegated the Hebrews to aesthetic impoverishment because they could never draw anything. So this crops up in other religions, as you know, in Islam, against graven images. So we have that compulsion against no God but my God, and no other gods but my gods, and you must not draw pictures of that as well. So speaking of Moses, when he comes down, what does he find the people doing? Worshipping a golden calf. Why a calf? Because the Canaanite culture at that time was the most successful cultures in this particular region. And the Canaanites had their own god, didn't they? Baal, after whom Baalbek. And Baal was the bull god. And why was the bull god important? Because everywhere in the world today, the cow represents, in my view, the most culturally significant food source of all humanity. It is not particular to any ethnicity. It is not particular to any bit of geography. It's everywhere in the world. Why? Because it is life-sustaining. If we didn't have the cow, what other food source? How many chickens does it take to make a cow? You know, that's hypothetical, of course, but you understand my meaning. What other food source would replace it? Because it gives us meat, milk, every form of dairy product, leather, so forth. It is essential to life growth. And it didn't occur to me that this was important to watch the bullfight in southern Spain many years ago. And it occurred to me that this was not simply a spectator sport, but something much deeper and much richer. It was the ritual and divine, in many cases, killing of the bull in order to domesticate the cow, because it is so essential for all civilizations. So the Canaanite bull god, Baal, was competing with the Hebrews, if I can say it this way, for their national identity. So it's essential that you wipe out this other culture that is impinging on you and encroaching on you. And so if you read in the first book of Kings, chapter 18, you will find Elias has a duel with the priests of Baal. And they're dueling, of course, on a mountain. All significant events take place on a mountain. And he's challenging the bull god against Yahweh's power to create fire on water. Well, it's hypothetical whether it really happened or not historically, we don't know. The point is, Yahweh, of course, wins. But the next thing that happens is what? Elias and his colleagues kill all the priests of Baal. There's 450 of them. It's one of the first genocides in the Bible. But the point is, symbolically representative, of the Hebrews finding their own identity absent the encroachment of another culture, another civilization. It's a very important one that you read in the first book of Kings, chapter 18. A genocide, a Hebrew genocide by a prophet who thinks it's okay to kill other people's religious clerics. course, there are contemporary parallels to this, I'm sure you know about. So this is Hammurabi and this is Moses. Now, I'd just like to walk you through a few other the important people that I think had a role to play in terms of events and figures in terms of this civil law that I want to talk about. The next one is Lycurgus, who's the Spartan lawgiver. He created a constitution, but the most important thing he created, and the thing that the founding fathers of the American Revolution followed, was a Senate. It endured for 1,000 years or more, because what was the most important parliamentary feature of the Roman civilization? The Senate. Quite apart from the emperor, but there was a Senate that laws. That was started in Sparta, in the Peloponnese, in about the 8th century before the Common Era. The next one, of course, is Numa Pompilius. Well, I say of course, but he's a lesser-known figure. But he's in Rome about the time that Rome was founded, shortly after Romulus, after whom the name of Rome is derived. So Numa Pompilius was a very pious man, very religious, but a very simple man. And the group of counselors went to him, saying, we need you, a strong man, to impart our form of government. So they elected him to come and to rule. He had one of the most successful reigns as king in history. 43 years, no insurrection, no conspiracy, nothing of turbulence. So the counselors were right. They picked the right man for the job to keep the peace. That was the most important thing, to find order amongst a tempestuous society and group of people. The next important man, the thing that I think is one of the most important in the history of law, is Solon. Now, Solon was also called upon by the Greek people to bring peace and order to the community. But he did it very radically. In fact, one of the most radical changes of all. He canceled all mortgages and made it a law to forbid them to foreclose on those mortgages. This would be appropriate today in the United States, I think. But the point is, he instituted all kinds of reforms. But the most important thing is, he founded a constitution with separate branches of government that succeeded for hundreds of years. And it was based on people's rule. This idea would later be resurrected, of course, in the United States, of followers of European leaders, intellectual leaders, and the phrase became known as popular sovereignty. In other words, rule by the people, not by the gods. So there's always this tension between whether the deities will let us do this, whether they will interfere, whether they will decide our fate, or whether they will let us decide for ourselves how we should govern ourselves. This is Solon, very, very important part in the history of constitutional government, who founded a government based on people's rule and the rights of people's rule, and then instituted all kinds of injunctions from that constitution. I think very, very significant role to play in that. Okay, so we all know that today there are groups of rising fundamentalism, religious fundamentalism, that threaten the rights of people, the rights of institutions. And we can find this among American evangelicals. We can find it among Hindu devotees. We can find it, of course, among Islamic extremists. So it's irrespective of a given religion. It is a rise in religious belief that tends to confront the complexities, economic, political, social complexities of life in the world, global marketplace. So now we're going to fast forward a little bit farther to the American Revolution. And if I will, I'd just like to read from you some people who originally were very, very important in the development of American constitutional law, and then show you why this tension between civil law and what I call religious imperatives was always formed at this time. The most significant book, not only in the history of physics and mathematics, was Isaac Newton's Mathematical Principles of Natural History. It was published in 1687. It's a significant date because it's 100 years before the American Constitution. But in it, of course, Newton outlined natural laws for how the universe functions. Why is this important? Because the next logical step is what? There are natural laws that govern human actions. natural laws that govern how people relate to each other in a social order. So people began developing this. David Hume, Thomas Hobbes in the Leviathan. We find Jean-Jacques Rousseau in the Social Compact. Now you have people's relationship with government. Sometimes that leads to revolution, as it did in America and France. Other times, that compel people to change their mind about the political reality, the development of political science, for example. These key ideas influenced the American framers of the U.S. Constitution. Ideas like all men are born free, that's a phrase that comes from Thomas Hobbes. It doesn't come just from Jefferson. Jefferson read Hobbes, of course. But these were Enlightenment ideas in Europe that got transplanted into a political reality in the United States. So America was a colony, series of 13 different colonies. They were all, if I can use the word lightly, sovereign. That is to say, they were independent. But they really weren't independent. They had English governors. They each had their own predominant religion that governed them, and so forth. And there was necessity to have a different kind of union. Once independence was gained, from 1776, when the Declaration of Independence was formed, with all of these noble principles attached to it. Then by 1781, when the British were defeated at Yorktown under General Washington, it was necessity to have some kind of unity, obviously for economic reasons, trade purposes, commerce. The new nations, the new colonies were now independent. They needed some kind of unity in order to attract, foreign investment. So that unity was the Articles of Confederation, a little-known document in U.S. history that preceded the Constitution. The Articles of Confederation had no executive, they had no judiciary, and they were only a very loosely organized legal basis. It would be very much today like a limited partnership, where groups of people make a small investment, and together they have a business relationship. That's the Articles of Confederation. Obviously, they couldn't last. Once the war was over, it was such a weak, fragmented unity, there was no reason why New Hampshire and Vermont, for example, would come to the defense of Georgia, which is very close to the Spanish territories in Florida. Nor was there any hope that perhaps Georgia or the Carolinas would come to rescue New Hampshire. It was attacked by the French from the north. So there were still other foreign powers, does this sound contemporary to you, in the U.S. colonies that were dangerously close to wrecking the Union, so to speak. Not only was a new document was needed, some kind of new stabilization of a political order was needed. So the conventioneers got together, the delegates from the various states got together in Philadelphia, beginning in May of 1787, to found what today we know as the U.S. Constitution. Now, I can simplify this for you, and I'm sure some of you are already familiar with this, but the Constitution of the United States is nothing more than the establishment of a federal government. It outlines the executive, the legislative, and the judicial branches. It was only later, when it was necessary for the states to ratify this document, that it became necessary to add personal freedoms to it. We call those the Bill of Rights, and it's the first 10 amendments of the Constitution. Now I bring you back to that quote that I started at the beginning, which was, Congress shall pass no law respecting the establishment of religion or prohibiting the free exercise thereof. So, each individual state had predominantly religious religions. In fact, in Virginia, in the time of James Madison, it was a crime to go to a Methodist church because it was an Anglican state for all practical purposes. So the government had to be neutral with regard to religious practices. The people could be religious because the government prohibited them from interfering with any people's religious practices. But it had to be neutral with regard to its own. Now today, even Americans who don't understand their own civil rights, sad to say, believe that they can impose their religious practices or their religious beliefs or their interference in government to try to get government to restore God in the classroom or to put the 10 Commandments in a justice building. The government can never do that. It has to remain neutral in order to protect the rights of religious minorities. There can never be any religious interference by the government, nor can they prohibit people from worshiping as they please. That's the basis for all government activity. And it's the first part that we find in the First Amendment to the Constitution, before the Constitution grants personal liberties, among them freedom of assembly, freedom of the press, freedom of speech, and so forth. But the most paramount thing to the constitutional framers was this absence of religious domination in any government case, doctrine, or whatever it happens to be. So let me just stop there for a minute and see if you have any questions, because I want to end and have you ask as many questions as you like. I've gone through this very quickly, but I would like to have...
You said that the states had their own religious framework. How was that abolished subsequently?
Well, by the Constitution. The Constitution forbade it,
This particular...
And the national government then had to supersede state prerogatives. So the state laws were superseded by national legislative laws, and subsequently, of course, by U.S. Supreme Court decisions.
So they were repealed?
They were overridden, exactly. Sir?
Was that on the basis of the First Amendment?
Yes.
But the First Amendment says Congress.
It does, but it was later ratified by the Supreme Court to include the states. So states would then, the first one was in Madison versus Marbury. It was in 1803, I believe, something like that. Hold me to it, but check Madison versus Marbury. It was a decision, I think, in 1803.
So
pretty sure.
That applied also.
Which decided that these things. It may have been a later one. I'm not sure, but for sure, the Supreme Court did decide that states could not have laws that did this either. Sir?
Regarding the Supreme Court, when was it established as an institution having its own independence? Part of the Constitution, or
the Supreme Court is in the Constitution. It's Article 3 of the Constitution. The first one is the legislature, and then the executive, and then the Supreme Court. So it outlines the three branches of governments and what they can do. And so it was established immediately after the Constitution, the Supreme Court. John Jay was the first one. And the Federalist Papers, which Madison, John Jay, and Hamilton wrote to convince New York to ratify the Constitution, are part of the most important documents in American constitutional history as well.
And what sort of mechanism of enforcing these decisions?
Well, it's a supreme law of the land, so I guess they would be held in contempt, wouldn't they? But you do recall that when desegregation of schools took place in 1954 and 1955, there were a series of decisions that General Eisenhower, who later became president, had to federalize state militia in order to compel them to follow the Supreme Court's decision. And they had to march young African American children into schools because they became desegregated.
Was it the commission or the authority of the Supreme Court?
Yes.
Naturally on the states.
Exactly.
Joining the union meant that you would submit to.
Yes. But of course, it was imperative to get the states to agree to the Constitution to begin with. They didn't lose anything. It was the creation of a whole new form of government that had never existed before. We went, as Americans, from the abolition of monarchy and the abolition of an English parliament that was deciding what to do in the colonies, to forming a whole government that had never existed in the world before. It was not just creating a person who was going to run a government, but the creation of a new form of government that now exists, of course, in other parts of the world as well, which has a judiciary, a legislative assembly, there are people that are elected, and an executive who are also elected. So if it's bad government that you see that's taking place, and excuse me, I think we had one 8 years ago, the last 8 years, you get rid of them, you vote them out of office. So this is a democracy in which the people count, the sovereignty of the people. So we have popular sovereignty, the sovereignty of the people, the rule of law, trial by jury, due process. All of these things have been engineered now to create a life for a people that didn't exist before during the time of the colonies. And that goes back a couple of hundred years. I mean, from 1620 all the way up to 1787, or 1791, when the Constitution was ratified.
And each state had to pass its own legislation guaranteeing freedom of worship.
Well, when they...
Not enough to be proclaimed the First Amendment. But each state had to make a piece of legislation.
They had to, the delegates to the conventional convention voted as states. They didn't vote as individuals. So half of the states had to vote to ratify, to send it to the states for state ratification. Once the states ratified it, then it became law. The Constitution became an accepted document that became the basis for the law of the United States. A national government that succeeded over state governments. Very, very important. And we may disagree with it, but the choice is ours, that you can vote people out of office, except Supreme Court nominees. They're there for life. They're like the Pope, who, by the way, still has the title of Pontifex Maximus, which was the title that the emperors had. Not only the emperors, of course, were not only rulers of the empire, so to speak, but they were also the chief clerics. So Pontifex Maximus meant that the emperor was the chief cleric. But it's a title the Pope still has. A little bit of historical trivia. But you can have. Are there any other questions I can answer for you?
Just one final one.
Yes, please.
The famous speech of Jefferson.
Yes.
After the Congress of the state of Virginia.
Yes.
Passed guaranteeing freedom of worship. I'm trying to place this in the context.
Well, Jefferson also wrote the Bill of Freedom of Religious Expression for the state of Virginia.
Right.
Before he was...
adopted
yes, that was adopted by the states. And that was the basis for some of the First Amendment as well. It's a good point.
This preceded the First Amendment?
Yes, it preceded that. Thank you for mentioning that. Preceded it in time. And of course, he's the same author. Or he was part of the same author, the committee that helped write the Constitution as well.
In this speech that he made a famous statement that we've done the right thing, this is a good law, but there's nothing that prohibits us
from changing it.
From any other legally, constitutionally, and so on.
Yes, as far as I know. That's right, as far as I know.
This is where the Supreme Court comes in.
Yes, well, the Supreme Court is the major branch of government because it decides legislation between the states and individuals. In the early days, individuals could sue to bring an idea that is found in Solon, the Greek lawgiver. That's an idea where he allowed individuals to go to government to bring a suit against government. That's where that idea originated. In the 5th century, before the Common Era, so 2,500-year-old, but it had never been instituted, of course, by states and sovereignties prior to that time, necessarily. You didn't have any rights. And of course, after the American Constitution, Jews didn't have any rights, Catholics didn't have any rights, slaves didn't have any rights, children didn't have any rights. People who owned property, who didn't own property, didn't have any rights. It was only much later that this, how shall I describe it, level of social consciousness rose in order to prohibit laws to take place that bring us now to a more diverse and acceptable form of democratic governance. Well, you've all been very attentive and very courteous. Thank you very much, Shukran, for your attentiveness, and I'm here to serve you and talk with you if you want later. Thank you so much again.
Any other questions?
Anything in the...
Yeah, I can run through these if you like, if I can. Many of them will be... Can I go through these quickly? And then if you have any questions, you go ahead and ask them. Is faith the only requirement for personal behavior? Well, I think, as I've quoted the First Amendment to you, that pluralistic societies have to be neutral with regard to religion. Otherwise, it complicates government, doesn't it? Because the question is, whose religion do we allow to predominate? That was a question for the colonies. It's a question for a lot of nations today. You know, in Canada, our northern neighbor, the Queen still initiates Parliament. It is still part of the Commonwealth. Here's Agamemnon, the king of Mycenae, and Clytemnestra, his wife. What a domestic dispute that was. and Hammurabi. Hammurabi received the scrolls from Shamash, the god at the time. So it was the deity handing down the laws, as it was in Moses' time. And of course, there's the old Mel Brooks story. I don't know if you've seen it or not. Where Moses comes down from the mountain. He's just about to get to the end. He's carrying 3 tablets. He drops one. He says, "I have 15 commandments," and he drops a tablet and breaks it. "I have 10 commandments." So, but again, it's the God, usually in thunder and lightning and a whole lot of smoke, that is receiving these laws from the deep. The same with Minos, the king of Crete. He received the constitution of Crete from his father Zeus. So,
any theories as to what the 5 missing amendments were?
Yeah, I don't know what they were, but if you want to know, you must go to the mountain and ask the deity again. Moses receives the tablets. That's in Exodus. It's actually chapter 19, also chapter 20, and you can find it in Deuteronomy 5 as well. I forgot to mention the papyrus of the knee, but they also have Egyptian injunctions about behavior, including in Deuteronomy, injunctions against venereal disease. So I guess they knew about it then. And here's Lycurgus, Numa Pompilius, Solon. Abolished Bronze Age justice, as I mentioned, the vendettas, the blood feuds, the clan rivalries, that sort of thing. And instituted a law of humans for humans. I say men, but that's the term that they use. And Justinian. I didn't mention Justinian, did I? Forgot to mention Justinian. Here's a code of justice that came into being primarily because of the development of Christianity, which was formed in the Council of Nicaea, as you probably know, in 325. About 100 years later, Justinian, who I think is probably the greatest of the Roman emperors after Augustus, realized that there had to be some compilation of all these existing laws. So he put them all together. And so the Code of Justinian is like 2,200 pages in 3 volumes. It's bigger than the Bible. And it includes all of the existing laws at that time. Now, all of this, of course, came apart when the barbarians, led by Alaric in 410, conquered Rome, and all of Europe went into the Dark Ages.
Was Justinian not in Constantinople?
Yes, he was in Constantinople, but Alaric was in Rome, conquering Rome, and sent Europe into the Dark Ages, and I suppose there are still some that think Europe is still in the Dark Ages in some parts. But Justinian was in Constantinople. And those laws, sorry?
So those laws continued?
They continued until 1453, when the Ottoman Turks took over Constantinople and renamed it Istanbul, which in Greek just means to the city. You go to the city. Istanbulis. And then Sharia law took over until 1918. So we had competing law systems. But the development and evolution of what I call a civil law, what some people call a secular law, it's not secular because it still had religious overtones to it until the First Amendment. It's neutral law with regard to religious imperatives. That's important. That government keep its hands off all religions in order to protect minority religions as well.
May I ask a question?
Yes.
You were answering regarding Hammurabi.
Yes.
These numerous laws that are so comprehensive were designed to regulate the society.
Personal behavior, yeah.
But he had to ground them in supernatural, divine,
yes.
Shamash.
They came from Shamash.
I suppose that this was a clever maneuver on his part.
Who knows?
Or was he convinced that Shamash came down to him and gave him those?
Well, it's always speculative to guess motives in history, isn't it? Not in philosophy, but in history. To guess people's motives on this. Perhaps it was a clever move. The point was, it was a tradition. It became a tradition that the gods were always the lawgivers. And that's why I used the plays of Aeschylus to show that even among the Greeks, and perhaps he was satire as much as anything else, it was important to develop laws from men, by men, and for men, that they could do justice in their own rights without the gods. And so that's a key development, it seems to me, not just in literature, but in political orthodoxy as well. The assumption in all of these injunctions that you had, you're going to do this, you're not going to do this, here's how you're going to treat your wife, here's how you're going to raise your kids, the assumption was that if you do these things, there would be peace in the common order. And of course, in Roman times, ordo, order, pax, peace, and justitia became Roman virtues. Augustine made them Christian virtues. They became then associated with Christian virtues as they had been Roman virtues prior to that time. But it was assumed that if you did these things, there would be social justice and social order in the realm, or whatever the realm was. At that time, it was the Roman Empire, which later became transformed into the Holy Roman Empire. And here we have the Articles of Confederation, the contractual agreement among states prior to the U.S. Constitution and prior to the establishment of national government. But they only lasted those few years, those 11 years, because they were inadequate. They were right at the time, but they could not form a common economic policy, they could not form a common political economy, and they could not have a unity, a political unity among those states that didn't involve economics and defense.